This video is going to be something very short, super crisp, but super helpful, because I am getting questions from you people as to what these preliminary objections are. Whenever you're filing any reply, written statement, etc., even a reply to a writ, etc., even a counter affidavit, you can take certain preliminary objections, which I advise you should take, because if you do not take those in your written statement, you may not be allowed to raise them later in the case, which may have a bad impact on your case, on your client. Therefore, through this video, I am going to tell you what these preliminary objections are in a super short, super crisp manner. Hi everyone, this is Advocate Isha Kapoor and you're watching Vlawgish. I have opened 2 petitions in my phone only for you people, just to make sure I am telling you a few preliminary objections to let you understand what this actually is. देखिए, preliminary objections is nothing but those statements which you make at the beginning of your written statement, at the beginning of your replies, after saying most respectfully show it, through which you try to show to the court that there is no prima facie cause, reason to deal with this case. In fact, this should be outrightly rejected. अब ये क्या हो सकते हैं? What are some examples of preliminary objections? See, in every written statement, you will find at least 2 to 3 objections, and you should make at least 4 to 5 paragraphs of your preliminary objections, detailing out why you think this case should not be entertained by the court. So, number 1 preliminary objection, which everybody raises and is definitely worth your time, is on maintainability, which means let's say it's a case which should be dealt with by the family courts, but the litigant has come to the civil court for that, maybe the high court or the other competent civil court. You say that this is that particular provision which says, this is that particular law which says that these kind of suits should be dealt with by the family courts. Why has he come to the civil court? Therefore, this suit is not maintainable here. This court has no jurisdiction to deal with the matter that has been brought before it. Second, when you're looking at the case, you should try to find out whether proper valuation, proper court fee has been paid by the plaintiff, the petitioner, etc. Which means there may be instances where the court fee payable on a sale deed may be in lakhs or thousands, but the litigants often neglect paying such fee and simply pay the usual court fee of 200-400 rupees. In those cases, you can take this objection of the court fee not being proper, the valuation of the suit not being proper. For the purposes of understanding this point properly, you should read the Court Fee Act and the Valuation Act also. If you face any difficulty regarding the practical aspects of the Court Fee Act or the Valuation Act, I suggest you should straight away go to any of the senior counsels. Even if you do not know that person, there is nobody who would not like to help you. Even if you find a random senior in the court and you ask them, "Sir, ma'am, I am unable to understand this concept of valuation, this concept of court fee calculation. Could you please help me a little? Could you please devote 10 minutes, 15 minutes of your time to me?" They'll be more than happy to do that, and I can say this so confidently because seniors only have taught me how to calculate all of this. So the second example can be of valuation, court fee, etc. Third one can be that of misjoinder and non-joinder of parties, which means necessary parties have not been joined. CPC, if you read CPC, you will understand the concept of necessary and proper parties. There may be cases where necessary parties have not been joined, or even if there are proper parties, but necessary parties are more important, or there is a misjoinder where wrong parties have been joined. You can definitely take this kind of objection in the beginning. You should take, in fact. Now, see how you have to write it down. I have also uploaded a video. I am uploading videos on drafting, so in those videos you will find how this kind of objection is drafted. Then other preliminary objection can be, this suit is completely sham, it's a concocted story, and of course you'll have to give your own documents as to why you say that this one is a concocted story, and how you have a completely different version as compared to what the plaintiff is asserting in the suit. And one more can be that the plaintiff does not disclose cause of action, which means why this suit deserves certain action by the court, what such incidents happened actually, which give rise to the offense, which give rise to the actual problem that has been mentioned in the plaint. So this can be one thing, that there is no disclosure of cause of action. पता ही नहीं चल रहा है सूट क्यों फाइल कर रहे हैं. One objection can also be that you cannot see where the plaintiff's right is flowing from. For example, if it's a suit asserting violation of copyright और वहाँ कोई injunction मांग रहे हैं, then you may say that they have not even attached, they have not even disclosed that they are the owners of copyright in the suit. They have not attached any kind of documents pertaining to that. So even plaintiff's right is not clear, then how can there be a violation of the plaintiff's right? These kind of objections can be taken. Then one more and the very important one is the objection related to limitation, which means you may say that there was a period of 3 years prescribed for filing of this suit from the date of cause of action, but now it has been 4 years and they have not sufficiently explained why their suit should be allowed after a delay of 1 year. Sometimes the litigants even fail to or forget to attach an application explaining the delay in their limitation period, so you can take benefit of that. Definitely you should take, otherwise you may not be allowed to raise that thing at a later stage. Whenever it comes to your knowledge that a plaint has been filed, it is a duty to file the written statement. I would say do it in the first 20 days so that there's no delay. If the court says you have to do in the 30 days or it's also as per the prevailing law, then you should do it in that period, but do not delay more than that. Then other objections can be related to facts such as this is a suit based on a very trivial thing, or we had some rivalry and that is why this has been filed, or that the suit is a counterblast. So preliminary objections are those things which you have to say in the very beginning, due to which the court may make up its mind by reading those initial preliminary 7-8 paragraphs only, that this suit is not deserving to be heard, and therefore we should outrightly reject it. Or even if they do not do so, even if the court thinks that no, we should hear it, but these kind of objections that you've taken will have a powerful impact on the judicial mind of the court that is dealing with your case. And definitely it is very important to take your preliminary objection drafting very seriously. If you are a novice, if you are new to drafting replies, etc., take help from somebody you know. Ask them to just check the draft once and give honest opinion about it once to you, so that you perform better next time, and so that no error creeps in your drafts, and so that no problem happens to your clients also. Wishing you a lot of luck, lot of money, lot of clients, lot of fame, and lots of good health, peace, rest, sleep, family time, and whatnot, whatever you desire and whatever is good for you. With this I can just say that I'll meet you again very soon with a new video on a new concept. Bye for now.